You had mentioned that the judge won't take notice of the Trenzi versus Pagliaro case if you enter the court as a defendant.
Mm-hmm.
Okay. Just a hypothetical. If you enter the court as a defendant and you make objection to the lawyer speaking, but the judge continues to rule in his favor, can you still go back from that point or forward from that point and claim void judgment?
The problem, like I said, this is one of the very first things I talked about way back in August when I first started doing these things. If you don't establish the rules of the court on day one, you have no right to object to anything. So all these other people, these gurus yell, well, if you don't object, you don't set up yourself for anything to an appeal. Well, you know what? The judge was just basing his rulings and his objections and his sustaining your objections or overruling them based upon the rules that were before him. So all that's going to happen on your appeal is going to say, did the judge not act under the rules of the court that were before him at the time? You're going to say, no, he was in 100% compliance with the rules that the moving party said, we're going to play baseball running from third base, second base, first base. And you're coming in now saying, no, judge, we've always done this for the whole entire creation of mankind. We've always ran first base, second base, third base. And the judge would be like, you know what? Overruled. The rules that are before this court this time is what the moving party established. If you didn't like the rules that he was moving this court under, why don't you file your own claim? And say, those aren't the rules, judge. These are the rules we're supposed to be following. This is the way the court's supposed to be moving. Well, then file your claim. And we'll determine whose rules prevail. We'll say, okay, what's the rules of the contract in that document between the two people? And then the judge is going to put on his judge hat, his arbitrator hat, and he's going to determine what is expressly or implied within that contract. Then he's going to take into consideration who wrote the contract, who's liable, who signed it. Is there any kind of a fraud in factum or fraud in inducement? Is there any kind of within his contract? Then the judge is going to put on his thinking cap and try to figure out just what's going on. Who's trying to screw who? And then if you don't like the judge to interpret the contract, that's when you call in a jury. And you tell in the jury, say, well, I want a jury. You know, I don't trust you, Judge. I think you're in collusion with this guy who wrote this contract. And the judge will say, fine. You want a jury to interpret it? Have the jury interpret it, because the jury is supposed to interpret the facts. And the facts are, this is the contract. Is this a contract? Yes or no? I want the jury to determine, is this or is this not a conscionable contract? Yes or no? And then, but you'll say, well, wait a second, the judge interprets the law. No, the jury could do both. And the contract is the law, and the facts are, does this or does this contract not exist, or does this or does this judgment not exist? You can let the jury determine that. The jury gets to determine both if you choose. But it's up to you. And like Greg tried to say before, all the statutory jury is useless, da-da-da-da. And I said, well, you can rely on Blackstone's commentary. It's, I think it's volume 3, section 372. Or it's volume 4, 372, which says the jury at its own peril may determine both the facts and the law for it. And then no judge could overrule it. So, yes, can you go back to the common law where the jury determines? And I explained to everybody how William Penn, Pennsylvania, how he got saved because the jury said we're not England anymore. We're going to do it our way here in the United States of America. Well, before it was the United States of America. It wasn't even Pennsylvania yet. You know, that's how it became William Penn. That's how far back that case goes. But that, to me, is when this country really got rolling, when the people said we had enough and we're going to make the decisions on our own. We don't care what they're doing 2, 3, 4, 5,000 miles away. We're going to, it's like an Eskimo is going to do. We don't care what Washington, D.C. is doing. If I walk into this schoolyard and there's a polar bear coming across this parking lot and I got a .22 in my pocket, me and my kids are dead. What am I going to do? Sue Barack Obama? This is ridiculous. I'm going to pull out my bazooka out of my backpack and I'm going to blast a hole through that polar bear. Sue me if you Obama.
So simultaneously, as they're filing a complaint or claim against you, you need to enter your own claim into the court.
Yeah.
So that when you meet when you meet in court, there's 2 claims before the court.
There's 2 claims, 2 sets of rules, and God bless you, because there's only one claim, and the other side is bringing a complaint.
Right, and the complaint's going to be from the lawyer.
The complaint's going to go underneath the claim. It has no.
I got you. I got you. Perfect. Crystal clear.
Yeah, but like I said, you guys got to be careful when you merge yourselves with a machine in a 2-dimensional world. Yes, can you use a claim to trump these guys? Absolutely. But I try to say to people, do you understand what's going to happen when the banking institutes realize that they're operating in the United States of America and we have these rules and they're going to be basically written out on a rail? They're not going to come back. Now, do you folks have a new currency system for us to operate under?